Well, thank you very much for joining us on the program today. The election may have come and gone, but there are issues calling for attention, particularly alleged infractions and irregularities in the just concluded polls. Although the PDP candidate, President Goodluck Jonathan, has since congratulated General Muhammadu Buhari, but the party has vowed to challenge the result of the March 28 polls in court. On the program today, we will be dissecting Nigeria 2015 elections from a judiciary and a legal perspective. I am Frank Omalape, and this is Judiciary Today. Glad to have you back now on Judiciary Today. My guest today is Dada Awoshika, a legal practitioner. Thank you for joining us on the program today.
You're welcome.
Well, from a legal perspective, what is your assessment of the 2015 general elections and, of course, the provisions of the Electoral Acts upon which the just concluded election held?
Well, my view is not different from any other Nigerian out there. I think the mood in the country is that of, excitement. People are actually happy that at least for once we can conduct an election, get the results announced without bloodshed. And I think I give that to the improved technologies that the government of the day has decided to brought to the use. We are actually excited that we can on our own conduct election that others can take a cue from. We have always been seen to be the giant, but over the years we have not actually put up such a magnificent approach to our electioneering process. So this time around we actually came out smoking, and the entire community, international community, the world community is delighted with what took place in Nigeria.
You are a legal practitioner,
yeah.
But looking at the electoral, because a lot of people are saying that the success of the 2015 elections was anchored on the Electoral Act that we have amended in 2010.
Yeah.
Now, what are your thoughts on this as well?
It is a big step, and then we are not there yet, if you ask me. I'm looking forward to the period we're going to really tailor our electoral process towards electronic voting. Now, what we have achieved, in my mind, is what has already been anchored under the Electoral Act as amended in 2010. And I think by the time we take a stock of what happened in 2015, that we need to take a step further by introducing the electronic voting, which is, as we speak, forbidden under the 2010 Act, Electoral Act. So, yes, I will give a pass mark for the Act for coming to our head when we needed it most, but I think we are not there yet. It is an exceptional election. It is an election which we believe, within the context of what we have been able to deliver to Nigerians. So in my mind, yes, the Electoral Act has come in to, in a way, plug some holes, the deficiency in the former Act, particularly the one of 2006, and I suppose there needs to be more improvements. We need to improve on the shortcomings we have observed in the 2015 election. So basically, I'm looking forward to when we're going to talk about electronic voting in this country, such that you can, whenever you make up your mind before the D-Day, you can even vote. You don't need to queue to be accredited.
But with what we have now, would you say we have a very perfect electoral law in place at the moment?
First of all, I suppose the quality of leadership needs to be addressed, and we need to raise the bar from the minimum standard. Now, I do not see any reason why we cannot allow the minimum standard to be bachelors of science or bachelors of art, or just graduates, university graduate, to be the minimum. That's one thing we have to look into. And at the same time, I suppose in order to save resources of the states, lawmaking process must not be made full-time.
Okay.
It should not be made full-time. So if there is a particular amendment to be considered, I think that alone should be looked into. Now, we don't know what goes on in the National Assembly in terms of their finances. They are not prepared to disclose, irrespective of whatever Freedom of Information Act you have. But ask yourself, is it a job that should be done on a full-time basis? No. That should be looked into too. And the issue of electronic voting, because it is not ideal for Nigerians of today to go out in the morning for accreditation and be asked to come back 2-3 hours later. You can't do that to a 65-year-old, 75-year-old man who is interested in the progress of this country. That needs to be looked into. And a whole lot of other areas too.
The electoral law as amended in 2010 specifying age as above 40. Do you think age should determine what should be there, even if it was the right candidate in the first place?
In my mind, age is of the mind. You see, the quality of people we have making these laws is also very important. Maybe because of our values, we feel that if you're going to be the president of Nigeria, you should get to a particular age before you can think about, assuming such office. Maybe because of the demand of that office, maybe because of the sort of wisdom they're expecting from someone who has attained a particular age. Okay. That could be something I think we shouldn't have any qualms with. If it is for the position of public governorship or presidency, there could be age limits to it. It has not done any harm. But the problem we should be looking into is the quality of people that are to be appointed or elected to some of these sensitive positions. Age has nothing to do with it. Yes, there could be restriction as to those that can aspire to such office. Don't make that error. If you don't have such limitation, somebody of 25 with massive wealth can decide to say, okay, it's my turn to run for the presidency.
So are you saying Nigeria of today has gone past that level when you talk about somebody of such who should contest?
Very highly responsible is the position for highly responsible individuals. And if you ask me, the affairs of the state, management of the affairs of the state is not for someone who just feels that I have money to run the show. Not exactly like that. So educationally, you must be up to it. Not only the financial side of it. Educationally, you must be up to it. You must be someone that has excelled in your chosen endeavor. And that must be for everybody to see before you even talk about assuming a public office, in my mind.
Looking at lawmaking, whether it has to do with the constitution that is guiding the electioneering process in Nigeria or the Electoral Act, how long do you think a particular guidelines of electoral acts, our constitution, how long do you think it should remain? Or talking about check and balances?
We should allow this particular one that we are still feeling, we are still buzzing over, to continue to guide us for now. I suppose that the amendment effected in 2010 has been able to, bring the required benefits, and we should allow it to continue to be the guiding statutes in the course of our electoral process for now. Now, if there is need for us to change or to amend, I think that will be dependent on the circumstances that may prevail at the appropriate time. The electoral law has properly constituted, in my mind, as really giving Nigerian hope in the course of our electioneering activities.
Well, let's quickly take a break now. We'll come back and discuss more. This is Judiciary Today. Don't go away. Glad to have you back now. My guest has been Dada Woshika, a legal practitioner, and he's still with me on the program today. But let's get to this question now. The PDP has vowed to challenge the just concluded election in court. What is your take on that?
They have a right to challenge the election if they have enough evidence to show that there are violations, there are breaches of the Electoral Act. Not minding the fact that the president has accepted, has conceded to the process. If there are grounds to challenge the election, yes, they can go ahead and do that. And mind you, the Electoral Act, that is part of what we are discussing earlier, that we now have a robust electoral law which has really given whoever wishes to challenge the conduct of any election the grounds upon which to predicate such challenge. So if the PDP as a body feels that there is violation of the electoral process, they are at liberty
to do so,
to bring petition, election petition, to the appropriate venue.
Well, April 22 is the new date for court ruling on the eligibility suit on the candidate of the APC, who is now the president-elect, General Muhammadu Buhari. Would it be necessary to rule against it, knowing his full status?
If you ask me, that is the most tacky question since this program commenced. But I can tell you something. We have pre-election matters and we have post-election matters. Legally, qualification or disqualification of a candidate is not a pre-election matter. Now, if a party has nominated a candidate to the electoral body and this electoral body has cleared this candidate, the decision of the electoral body cannot be challenged. That is the law as we have it now. In fact, that much is clear in Falai against Obasanjo, number 2. It was a 1999 decision. Now, the point I'm trying to make is this. General Muhammad Buhari's qualification to be the flag bearer of APC was under attack in a court. I agree that qualification and disqualification are matters for the electoral law as well as, you know, the constitution. Now, someone has gone to court to challenge Buhari's qualification to stand for an election. My law, judicial authorities have made it clear that if it is about nomination, you can't challenge that. If it is about qualification or disqualification, it is a post-election matter. So, in my mind, it is something that should be contained in the petition that they wish to submit to the appropriate body to ventilate. So,
you mean PDP?
Yeah, it is. If they are not satisfied as to the educational qualification of General Muhammad Buhari, yes, they can actually insert it as one of the grounds. Okay.
But considering the new status of General Muhammad Buhari,
yes,
do you think the courts might want to rule against Buhari?
I'm not going to even consider. I'm not going to even consider myself with the new status of General Muhammad Buhari. I would rather prefer to limit myself, you know, to what is before the court that has adjourned to the 22nd. Now, what I believe is before the court is a pre-election matter. Okay. Now, the court will now have, well, I'm not supposed to have any say on this matter because it's a matter that is sub judice. But it's a matter also that is before public space. And I'm just trying to let you know that what this fellow has brought to court is a pre-election matter. You have to now ask yourself, does that court have jurisdiction to deal with that matter, being a matter that ordinarily ought to be included as a ground for standing in for an election?
Well, is before the Federal High Court.
Yes.
The Federal High Court
Yes.
in Abuja.
Yes.
So, are you saying the court now has no jurisdiction to, to rule in this matter?
What I'm just trying to let you know is that appellate courts have made it clear. Appellate courts, there's so many decisions, have made it clear that qualification or disqualification of a candidate is a matter that should be brought before the election tribunal. Now, the point I'm trying to make is that whoever INEC has cleared to stand for an election, you cannot question INEC's decision, because that's exactly what these people are doing in Abuja. They are more or less questioning INEC's decision to clear Muhammad Buhari for violating the electoral law and the constitution.
At the time this case came
Yes,
up,
yes.
APC questioned it, even when it was adjourned.
Yes.
Do you think it would be out of place to question why the case was adjourned to after the election?
Well, I'm not the judge. I won't even...
Because that's what APC...
I won't... or PDP?
I mean, the APC was really questioning when it came up before the election.
Yes.
And when it was adjourned.
I understand that what the APC essentially was questioning is the fact that the court does not have jurisdiction because the matter was commenced by an originating summons, and secondly, that the substance of the matter itself is criminal. That's my understanding of what APC lawyers are saying. But the point I'm trying to make to you now, Frank, is very simple. For you to contest whoever INEC has cleared is something that, in my mind, has been addressed in series of judicial authorities. You ought to just wait, let this fellow contest, after which you can now challenge the validity of his election and probably bring election petition on the ground that he was not qualified to contest that election, or is not qualified to even stand for any election whatsoever. That's the point I'm trying to make.
Well, do you think PDP will want to do that at this point, now that the election is over?
Why not? Not just stopping PDP from putting his qualification into contest. Why not? They can as well decide to say that, look, this man does not have the requisite educational qualification to stand for an election. They will still put you there, but they still need to lead credible evidence to that effect. And that is a big task for them, to lead evidence to the effect that General Buhari does not have minimum educational qualification to stand to stand for that election. That would be a tough one.
Now, you said earlier that we have a very robust electoral act in place at the moment.
At the moment.
But a lot of people would not agree with that. But going forward now, what lesson really legally, from the legal perspective, what lesson can we learn, and how do we move a step forward? Talking, of course, we have elections coming in 2019.
I've mentioned earlier that there is no way you can have a document like the electoral process that will take care of the aspiration of everybody. But I think it has done a lot of good for the majority of Nigerians. It has brought transparency. It has even brought clarity into our electioneering activities. People who are not really happy with the process as we have it now, at the next legislative session, they can bring in proposal, and let's keep the conversation going. We have to keep talking. For us to develop, we have to keep talking. Let us know what they feel happened, which of course something better ought to have been done. I'm not saying that the electoral process the electoral law or the constitution as we have it now are perfect document for us. No. I'm saying they have brought in extraordinary benefits that can actually unite us as an entity. Because judging from the campaign of calumny from the major political parties preparatory to the election, some people actually decided to go to their villages. Some people moved their family out of this country. But here we are, Frank. I will lay most of those, the reason why we are, really delighted for the success achieved to the law itself that actually guided the process up to today. So it is not a perfect document, without doubt, but it is a document that has brought benefits. Yes, we can still amend it. I'm happy that we all now know that government is for everybody. If they are not happy with what they have seen, they have opportunity to even bring in a private bill towards, amending, the Electoral Act in the next legislative session.
That's it on the program Judiciary today. Many thanks for watching. I've been your host, Frank Omalape. Until I come your way next time, same station, same time. Bye-bye for now.